Your Honor made some remarks, but I'm not 100. The yellow light signals
That you've got one more.
1 more minute.
Yes, as you can see in the numbers here, it'll tell you exactly.
I see.
Okay.
May it please the court, my name is Donald Barrett. I am representing myself in this matter. This matter has a history that goes back almost 7 years, which I think is worth at least noting. Grievance filed in July of 1999. The formal proceeding stage has been 44 months in length. For all but 16 months of that 44 months, I have been pro se. For the 16 months represented the bulk of the hearing committee. Hearing process during which I was represented by Michael Reutman, Esquire, and then I took the matter back into my own hands following what I considered to be a very disappointing result from the hearing committee. I just take the opportunity to say that no negative implications are intended by that in the direction of Michael, who's a fine gentleman, a fine lawyer, and did a good job. There are really two separate.
I have a question for you, based on the facts of this case. You say that that you had no intent to steal, and that was shown by the fact that you returned the money voluntarily.
That's correct.
Okay, but what if, isn't that fortuitous? What if your fortunes had turned sour and you wouldn't have been able to repay?
If I had not been able to repay, it wouldn't have carried any implications, Your Honor, for the innocence of my intention in the first place.
But it would have an effect on the deprivation of the people whose money you were.
Oh, there's no question objectively if my fortunes, if I had gotten hit by a Greyhound bus, all kinds of things could have definitely, and the matter that came up came very, very close to throwing this thing into something of a major scandal. But the question of my intent at the time is really central to what we're talking about today. My intent was, as I've stated on repeated occasions, was nothing more than making a courtesy advance to myself of 1 or 2 or 3 weeks duration, the purpose of which was to turn an otherwise Byzantine exercise, particularly up in Maine.
But we hear that. The reason I ask is because in so many of the cases we hear, the attorneys will say, well, their intent was to repay, but the reason they needed the money in the first place was because they were in bad financial circumstances, and then they just kept repeating themselves or getting worse until they couldn't repay.
That was not the case here,
But that
Your
could
Honor.
have been, I'm saying. So the fact that you, fortuitously, you had enough money to repay.
Well, there's no question that I had a property worth $500,000 that was easily refinanceable. There's no question, as long as I got a mortgage discharge. The problem is that the people on the other side of the existing mortgage ran over the hill with the mortgage discharge. It took me 17 months to get it, and turned an otherwise easy source of repayment within a matter of a couple of weeks or so, destroyed it.
Right, but it seems to me you're trying to characterize this case as if it all hinges on whether there was an intent to repay. And it seems to me that, a fiduciary is not supposed to use someone else's funds for his own purposes, even temporarily.
That's not entirely accurate, Your Honor.
Well, we certainly do not allow it of lawyers.
That's absolutely correct.
To use their...
It's the mortal sin of professional ethics. I'm well aware of that.
Correct. And so here, while these were not client funds, they were funds belonging to a corporation of which you were the CEO. And
co-founder, yes.
Yes, and you took the funds and used them for personal purposes.
That's correct.
And even if there is an intent to repay, that is still a highly improper thing for a fiduciary to do.
Well, again, Your Honor, I don't mean to get stuck on this like a broken record on this one issue, but making an advance believed in good faith, and this comes down to a credibility issue, believed in good faith to be thoroughly innocuous, 2 weeks duration, completely free of risk, for the sole purpose of turning an otherwise complicated transaction into a very simple one, and thereby sparing not only me the need to take a significant amount of time off to do it in the more complicated form, but sparing the corporation the loss of me during what was an extremely important period of 100-hour weeks and whatnot. It was perceived, perhaps one could say after the fact, well, your perceptions were a tad distorted, Mr. Barrett, but it was perceived at the time as simply a harmless lubricant to allow me to get to a completed refinancing within the matter of a couple of weeks.
So Mr. Barrett, then I guess what you're saying is it's okay, it would be okay for a lawyer to do that if they had the right intent.
Not if it involves client funds.
Well, if they intend to return the money within a short period of time, it's okay.
No, not in the case of client funds, Your Honor.
Right. I mean, if you had done this
but the
with
analogy
client
is not
funds,
100%.
you would be disbarred.
I'm sorry?
If you had done this with client
That's
funds,
correct.
you would be disbarred.
In the normal course, that's correct.
Right. And the board, in apparent, and the single justice, in obvious recognition of the fact that these were not client funds, has imposed instead a 2-year suspension.
Well, that's a separate issue, Your Honor.
And that seems to me, you know, in other words, they're recognizing that what you did was wrong, that because these were not client funds, we're not going to impose a sanction comparable to what would have been happened to you if this had been client funds, but it's still saying it is that it is a violation.
You correctly described the outcome here.
Why isn't it a violation when you had a fiduciary duty not to do what you did?
That is not a 100% accurate statement, Your Honor. I've been operating in the corporate realm for the better part of my career. Corporations are always engaging in what's the word I'm searching for? Accommodations of their valued executives. It happens all the time. There were advances in Netfax to other executives in different contexts or other.
Oh, Netfax may well have agreed to give you an advance. If they had done so, there would be nothing unauthorized about it. The problem is you took it, you didn't tell them about it, and then when you weren't able to pay it back, you covered it up, you lied to someone else in the corporation to try and get funds from him. This was not something that Netfax had looked at and said, yes, it makes sense, Mr. Barrett is valuable to us and we're willing to do this for him.
Your Honor, I was Netfax. To look at Netfax, I had only to look in the mirror. I was Netfax.
You were, I forget his name, someone else was the principal shareholder, correct?
Well, there were two principal shareholders. I was one. The other one was Mr. Lombardi.
Okay.
Ironically, Mr. Lombardi was his wife, the ultimate source, when I got to December and realized that this was turning into a potential scandal, from whom I got the $130,000, lacking the mortgage discharge 5 months after the fact. It was from Mrs. Lombardi that I got the $130,000 that I repaid to Netfax. The point that I'm trying to make here is that
why didn't you execute loan papers?
I'm sorry?
Why didn't you leave a paper trail?
It's really a corollary, Your Honor, of the fact that I realize that after the fact, it's easy to gloss sinister motives on all this stuff. It's a corollary, I guess you could say, of two things. Number one, I saw this as a 1 to 2 week exercise, harmless, risk-free, and number two, we were working 100-hour weeks in that time period. It's hard to recreate the circumstances in which all this occurred. And as I said, if people want to, after the fact, say that my perceptions were distorted, That's one thing. But to say that I was conspiring to defalcate, it's just not the case. And I would like to address, with my time quickly running down here, I'd like to address one issue, and that is the proper construction of what happened, using the principles of the substantial evidence rule, and specifically three principal corollaries of that rule. The rule that you cannot turn an accused's protestations of innocence, that your disbelief in a respondent's protestations of innocence into substantial evidence. Number two, that you cannot read a negative inference into a set of facts that are capable of both negative and positive or innocent inferences. And number three, the entire record requirement. These are the three fundaments of the substantial evidence rule. If you look, the appeal panel, in very ably summarizing my position, you might say, the respondent disputes the committee's central characterization of his conduct. The drawing the check, he argues, was not a misappropriation of funds, but an advance he made to himself in his capacity as CEO. Viewing the transaction in this way, he harbored a sincere belief that the advance was an authorized, although voidable, instance of self-dealing on the part of a corporate officer under Delaware law. I agree with that entirely. Not a defalcation, and an action he reasonably expected to cure by repaying the funds before the corporation would be troubled by the issue of ratification. That also I 100% endorse, and we're talking about a week or two. When, through no fault of his own, he was not able to return the funds as quickly as planned, he admittedly made efforts to conceal his use of corporate funds, admitted from the start. I found myself in an extraordinarily embarrassing and potentially lethal, from the corporation's point of view, state of affairs, and I went into a mode of active concealment of this entire fiasco until I straightened it out 5 months later. This he did out of embarrassment at his inability to repay his plan, not as part of a more sinister scheme to conceal a defalcation. I could not have written that better myself. With the appeal panels.
But that was their description of your position.
I know.
That wasn't their finding.
No, I'm not saying that it was their finding.
It was a description of the position.
That's right. I'm saying they could not have written the description of my position better than I could not have written. The question then is, if you're going to look at this transaction in July of 1996, you can adopt one of four constructions. The first two, I think everyone will concede, would put me in a position of a private admonition, public reprimand, or less, if you wanted to factor in prosecutorial irregularities. And that is that I had the authority, an issue that I've raised and I've never gotten a ruling on in this matter, that I actually had the authority, or at least that it was debatable enough, the debatability was at a level high enough that I, although perhaps found in the end to be mistaken, I had reasonable grounds to believe I had the authority to make that advance to myself. Voidable as a self-dealing transaction under Delaware law, indisputably. But that the raw, ultra vires type authority existed. If you adopt either of those two constructions, 1 and 2, I think it's fair to say that the concealment still leaves, perhaps in some people's eyes, the concealment strategy a less than ideal odor, and perhaps that would result in a private admonition or a public reprimand. The next construction is that you say, no, Mr. Barrett. Although the innocence of what you were trying to do and the innocuousness of it and the belief, we'll buy all that, but we think that not only are you wrong that you had the authority, but you knew it at the time. That falls into a darker realm, but you're still in the private admonition, public reprimand realm, based on all the applicable precedent. It's a non-criminal, non-practice of law related, not aggravated by any material aggravating factors offense. And under all the applicable precedent that and at this point, I think I may be in the upper circles of people as far as knowledgeability of the sanctions in this area are concerned. I have been unable to find one sanction that would be harsher than a private admonition or public reprimand. The only construction is to say, no, Mr. Barrett, you were intending to steal these funds. That is to say, you either wanted to keep them permanently or you wanted you didn't have any credible, specific, basically guaranteed, but for the flukish developments that happened, plan in place to quickly return these funds and to keep them free from risk while they were advanced to you for the purposes that you've described. The problem is that the substantial evidence rule demonstrates clearly that there's absolutely no basis for that conclusion in the evidentiary record. The appeal panel alludes to the hearing committee's disbelief of my protestations of innocence, but that violates the rule that says that cannot constitute substantial evidence. Then they point to the hearing committee's reading into the concealment strategy, we'll call it, of an inference of sinister motives. But the concealment strategy can be equally explained as the strategy of someone who was well-meaning and found himself in the middle of a major embarrassment. Lastly, and then I'll shut up because I see the red light's long since on, the entire record requirement, thank God, as far as I'm concerned, for the entire record requirement. What it shows is the funds were repaid without any change in circumstances, certainly incompatible with the notion that I had some sinister designs when I advanced them to myself. What it also shows is that in the swearing contest between me and the nominal accuser, the self-same Mr. Lombardi, I won in a landslide. Every time there was a material dispute, putting aside this area and this area, he didn't even explicitly dispute, but putting aside this area, every time they found he was lying. He lost and I won the swearing contest by a landslide. And last but not least, you get into the question of reputation brought to the proceeding. Mine was blemish-free, a career characterized by not a hint of lack of integrity. And as to his, I just refer the court to Appendix A and to the rest of my brief. It speaks for itself as to what his record is. Under the substantial evidence rule and those three hugely important corollary or subsidiary components of it, I do not see how one can reach the conclusion that this advance turned temporary fiasco and ultimately righted warrants a 2-year suspension or any kind of a suspension of my law license. I'm not saying that to be arrogant. I'm not saying that to demonstrate obliviousness to my ethical obligations, something the hearing committee, until overruled by the appeal panel, apparently saw that as being. I'm saying it on the basis of what I consider to be my encyclopedic investigation of all of the applicable legal principles. I cannot see it. In all good faith, as God is my witness, I cannot see how you get from there to there under the law.
Thank you, Mr. Barrett.
Thank you, Your Honor. Thank you for the additional time.
Mr. Warner.
Thank you, Your Honor. May it please the Court, Robert Warner appearing on behalf of the Office of the Bar Counsel. The issue before this Court is fairly obvious and straightforward, and the issue is what is the appropriate sanction for a lawyer who converts non-client fiduciary funds to his own use, then makes false representations in order to get the necessary funds to restore the funds back to the fiduciary, and finally creates false accounting entries to cover that misconduct. Mr. Barrett has argued from the beginning of this case, both to the hearing committee, the appeal panel, and the full board, that his version, his facts are the ones to be accepted. Justice Cordy made an excellent point in pointing out to Mr. Barrett that the section he quotes in his brief, The section he quoted to this court is his version. But his version of this case has been rejected. In fact, the hearing committee went so far as to find that there was an attorney-client relationship between Mr. Barrett and Netfax. That was rejected by the appeal panel. Nevertheless, the appeal panel still concluded, correctly so, that Mr. Barrett had misused fiduciary funds. Just as Justice Sussman pointed out, there is something inherently wrong that Mr. Barrett doesn't get in the way he used those companies' funds. And his version of what happened, his benign, I didn't mean anything wrong version, simply is not supported by the evidence. The evidence in this case...
Let me ask you this. I mean, isn't it clear from the evidence, leaving aside whether this gets anywhere, wasn't it clear from the evidence that what his intent was with respect to how the money was to be used and that it was to be paid back?
The evidence showed that he took the $130,000, used it to redeem the mortgage, and then 5 months later, when the company's books was about to close and knew he needed the money, he made false representations to Mr. Lombardi in order to get that money. Any lawyer who steals probably at some point in the future intends on returning those funds.
But I think that's not the import, Mr. Warren, of the question, at least as I understand it. That is to say, first of all, this is not a lawyer at the moment. This is a fiduciary. Second, it is Mr. Barrett's position that it wasn't as if he had depleted funds, that there was a mechanism to repay the funds.
Well, if the mechanism was to refinance property, that never happened. If the mechanism was to lie to Victor Lombardi to get the money, that did happen. When faced with the opportunity of being honest and truthful to Mr. Lombardi and coming forward and saying, Victor, here's what I did. Back in July, I took $130,000 of the company's money and I spent it to redeem that mortgage. Look, I need to repay the company. The books are going to close. It's December 30th or the 31st. I need the money. Now, maybe Lombardi would or would not have given him the funds, but the point is that Mr. Barrett, when faced with the opportunity of being honest about what he had done, chose to be dishonest. And subsequently, when he was creating the disbursement schedule and the deposit schedule for the company's outside auditors, covered up his misdeeds and mischaracterized the $130,000 as an advance to Acorn Company, which is one of the companies that Netfax was doing business with, and then mischaracterized the repayment of the $130,000 as a repayment from Acorn. It's significant to note that this, or that these actions, Mr. Barrett's misuse of the company's funds, was not discovered until several years later, after he had been ousted as the company's CEO and sole director. And Mr. Lombardi, and there's evidence in the record, Mr. Lombardi had a forensic computer expert review the computer files for Netfax and discovered Mr. Barrett's letter to the lawyer up in Maine regarding the $130,000. It was only then, several years afterwards, that Lombardi knew or found out of Mr. Barrett's misdeeds.
I can't remember what the specific findings were. Maybe you can help me with this, but was there a finding that at the time he took the money, he intended to not repay it?
I don't think that finding was not made. The finding was that when he used the funds, he intended to at least temporarily deprive the company of the funds, and under any construction, whether it's chauffeur or any of the other cases that deal with conversions, that is enough for bar counsel to prove that there was at least an intent to temporarily deprive. And in this case, there was actual deprivation, because the company was without the $130,000 for at least a 6-month period of time.
But the best case against him is that he intended to temporarily deprive.
That probably is the best case. I'm not suggesting this. I'm not suggesting, nor nor does Bar Counsel have to prove an intent to permanently deprive.
Yeah.
Bar Counsel can prove an intent to deprive at least temporarily. And the evidence here supported that conclusion. It was found by the hearing committee. It was affirmed by the appeal panel. It was voted on by the board. And the single justice adopted the facts as found by the hearing committee, adopted by the appeal panel, and found by the Board of Bar Overseers. There are at least 3 single justice decisions in which the single justice has found that the conversion of non-fiduciary, the conversion of fiduciary funds by a lawyer, funds that are not client funds, have resulted in severe sanctions. In matter of Condell, a case where Mr. Condell was the executor of an estate, Mr. Condell converted funds that belonged to the estate to his own use, was found to have done so, and was disbarred. And the reason was that the funds were never repaid.
Did the lawyer in that case have anything to do with setting up the estate?
Lawyer in Condell was I believe he had drafted the will for the individual who passed away and left the money to the estate. However, there is a finding in Condell that these were non-client funds, but they were fiduciary funds.
I think the point, at least as I understand it, is yes, they may be non-client funds, but the opportunity arose, or the fiduciary relationship, in essence, arose out of the attorney-client relationship. Or, I mean, in this case, if he drafted the will, what position did the lawyer have? Was he the trustee or the administrator?
Mr. Condell was the executor of the estate.
Okay, which was something he drafted into the will, presumably.
Yes, that's correct.
Mr. Warner, let me ask you this. We are here reviewing the single justice's order, and in reviewing his order, I note that he goes through the arguments that were made. And could you be specific as to where you thought the single justice erred as a matter of law?
I think the single justice erred as a matter of law by considering the theft of fiduciary non-client funds to be different than a lawyer's theft of client funds. It's Bar Counsel's position that if a lawyer is a fiduciary and steals non-client funds, the same penalties that apply that this court has set out and affirmed in matter of chauffeur should apply in this context. It was Justice Cowan who pointed out in matter of Leo, and I think correctly so, that stealing is stealing. There are at least
But he's
5...
not he wasn't found. He has not been found guilty, as it were, of stealing. He's been found guilty of intending to temporarily deprive the client of money.
His misuse.
Yes.
He's been found to misuse funds. I can paraphrase that and say misuse of funds is misuse of funds.
Well, as Justice Graney pointed out, and he found, the matter of Leo persuasive.
I think Justice Graney, as Justice Cowan in Leo did, deferred to the board's recommendation. In both Leo and Cowan, the single justice followed the board's recommendation. Bar Counsel has consistently argued, both to the appeal panel and to the board and to the single justice, for that matter, that the same standards that apply in chauffeur, where a lawyer misuses client funds, should also apply where an attorney misuses fiduciary funds of a non-client.
Well, could I say, I understand the sort of philosophically or conceptually, that the underlying sort of moral turpitude, if you will, is of the same nature and arguably on the same level. But surely, our rules and the purpose of the BBO places a high value on the protection of clients as being the principal constituency out there that's to be protected by all of these rules. And doesn't it make sense that misbehavior of any kind, whether it involves funds or something else, that is directed towards one's client is going to be viewed more harshly than similar types of misbehavior directed at non-clients that simply may reflect on your moral fitness to practice law, but but you haven't literally committed the ultimate sin of harming your own client.
However, time and again, this court has said both in single justice and in full bench decisions that the perception of the bar and the public is a driving force behind bar discipline cases.
Mr. Warner, you have just said that you have repeatedly argued to the appeals panel, you've repeatedly argued to the single justice, and I understand you're free to make the argument again and again, but it's not a position that the court has hitherto adopted, correct? That you view the status identically in both cases.
This court has not adopted that sanction. There have been single justice opinions referred to in my brief, Cahill, Condell, and Brown, where attorneys have gotten funds. Brown especially raises a question. Brown was the head of the Black Lawyers Association, received funds that were to be used for a project for the association, converted those funds to his own use.
But that wasn't a contested matter. I mean, that was an agreed-upon disposition.
Absolutely.
So I don't know what all of the facts
Well,
might
I think the point of Brown is that Brown stands for the proposition that if you misuse fiduciary funds, even if they're non-client fiduciary funds, you face a serious consequence.
Nobody doubts
There's no
that.
question about that.
There are at least five other jurisdictions that have found there's no distinction between a lawyer misusing client funds and a lawyer misusing fiduciary funds. Those cases are cited in my brief. One of them, matter of Greenberg, which was decided by the New Jersey Supreme Court. There they said that, quote, the ethical distinction between a lawyer who for personal gain willfully defrauds a client and one for the same untoward purpose defrauds a non-client should receive a similar penalty. That is the case that we have here. Even the ABA standard that Mr. Barrett seemed to rely upon in his argument that suspension is not appropriate suggests that suspension in this case is the appropriate sanction. ABA standard 5.11 says that disbarment is generally appropriate when a lawyer engages in any other intentional conduct involving dishonesty, fraud, deceit, or misrepresentation that seriously adversely reflects on the lawyer's fitness to practice. Certainly misusing fiduciary funds is those kind of actions. Standard 7.2 provides that suspension is generally appropriate when a lawyer knowingly engages in conduct that is a violation of a duty owed to the profession and causes injury or potential injury to the client, the public, or the legal system. What can't be lost in this case is not only was there a misuse of funds, but the misuse was exacerbated by Mr. Barrett's subsequent actions. He made false representations to the company's major investor. And then to cover up his misconduct, he made false representations to the company's outside auditors. This is a case that calls out for a sanction comparable to those that this court has set out and adopted in matter of chauffeur, and Bar Counsel suggests that this court should order that Mr. Barrett be indefinitely suspended for his misuse of fiduciary non-client funds and the misrepresentations he made to cover up that misuse. Thank you.
Thank you, Mr. Warner.
All right.